My name is Alice Young. I'm an attorney at Nusinov Smith. I've been practicing in estate planning and estate administration for 10 years. The two practices make up about 90% of what I do. And I consider myself to have a lot of experience, but I don't know everything. And so as I'm educating you as volunteer attorneys, I want to impress upon you, I cannot convey everything about estate planning in a 3-hour course. And you are not alone. As you tackle estate planning cases as a volunteer attorney, you have additional resources, not just this course, but also access to practitioners and other volunteer attorneys. You have additional resources, so when things come up that I didn't cover or that I covered but you forget, please don't feel like you're alone. Always ask, because you are being called upon to provide a high level of service to your low income client, and you are doing this as part of a team. When you serve any client, you have to take into consideration the client's own objectives for the representation. And so for estate planning, there are a number of reasons a client might be reaching out to MVLS for assistance. Estate planning can help clients ease their loved one's administrative burden when they pass away. If you leave instructions, it can make it easier for people to administer the estate. Another reason might be taking financial care of loved ones. Another reason might be tax savings. And although today's presentation is related to low-income Marylanders, so we're not going to talk about estate taxes, the boogeyman dangled by our politicians to make us scared. Estate taxes are an important estate planning consideration, but not related to low-income estate planning. We are going to talk about inheritance taxes. Inheritance tax is a 10% tax on the receipt of a gift related to the death of somebody. And we're going to talk about how that impacts low-income Marylanders. Some people have the goal of charitable giving, and so we'll talk a little bit about that. Some people have the goal of avoiding probate. So if you have access to Maryland Public Television and you see Susie Orman on the TV on Sundays, you will learn that probate is terrifying. And so some people who do estate planning want to avoid probate, so their families don't have to go to probate. We're going to talk about that as well. And some people come into the estate planning process because they've heard that if they go into a nursing home, their family might lose the house. And so protecting your house from medical assistance. As an attorney, you have to talk to your client about their goals so that you understand what they're trying to achieve. And so you can educate them on the things that they, their blind spots, the things they haven't considered in seeking estate planning. You, as an attorney, also have the ethical obligation to consider all of those rules of professional conduct. And so as applies to estate planning, first you want to know who the client is. You want to identify conflicts of interest. And you want to ascertain capacity. We're going to talk about the 3 C's here. Who is the client? MVLS is going to connect you with somebody, and that person may be the person seeking legal services, or it may be a child or a friend of the person in need of legal services. You have to figure out who the person is who you're representing so you can establish the goals and directions with that person and not just the person who's making the connection. You'll have the obligation to keep the client's secrets. And so although there may be other people in the circle that the client wants to keep informed, just make sure that you make clear with the client that you're that person's attorney and you are obligated to keep their information confidential unless they want to expand the circle of confidentiality. You want to look out for conflicts of interest and understand that in estate planning in particular, there's a client who may own an asset, but there are also other people who are interested in that asset. And we talk with Maryland volunteers a lot about a client's home, and The client sometimes isn't the only person who lives in the home, and the only person who relies on the home for shelter. And so there are people with adverse interests. You just want to identify those people and make sure that you are not taking direction from them, instead taking direction from your client. Specific conflicts of interest, make sure you don't write a will that leaves you a gift. It's not so much an issue in the volunteer realm, but you have to be careful, especially as an attorney, you have a special role in your family, and you have a special set of skills that when you go home for holiday dinners, your family members, your aunts and uncles, your grandparents, your parents are going to ask you, hey, I have a question. What do I do about this? Can you make a power of attorney for me? Can you write my will because you're a lawyer and you should do those things. So just be aware that you have to take special care if that's going to happen. Duties to former clients. There are times when an MVLS client will say, hey, I'm so grateful for the service you provided. Can you help my son as well? Can you help my friend? You have to just make sure that you're keeping those representations separate. You're taking information and observing your duties to the new client, and recognizing any conflict that person might have with your pre-existing client. And dealing with unrepresented persons, the circle of trust of your client may come into your conversations with your client. You cannot advise people who aren't under your engagement agreement. So just be aware of those different responsibilities. With estate planning, and again, often people seeking estate planning are people who need assistance. So they might not be able to drive to see you. They might not be able to figure out how to Zoom for a meeting. They might need help being in connection with you. But you must have a private meeting with your client without the support person there to establish the client's understanding of the meeting. So the client understands your obligation to client-attorney confidentiality, and so the client understands his or her central role in the planning conversation. I have to kick people out of the conference room regularly, and I want to empower you to do the same. If you have somebody, if you're meeting with a pro bono client and their daughter is with them or their grandson's with them, you have to say, you know what, thank you for the introduction. I hope this person feels comfortable. And by the way, I've got to ask you to leave. I have to have a private conversation with my client. And you have to make notes that happened, that you've asked somebody to leave, or take a note when they've returned to the meeting so that you can distinguish in your record who was with you when the client was talking about his or her planning wishes. You can have clients waive a conflict of interest via informed consent confirmed in writing. And so you may be familiar with dual representation. This is an example on the screen right now of the provision in my engagement agreement that allows me to represent a married couple where they acknowledge the conflict and confirm in writing by their signature on the engagement agreement that they waive the conflict. And in this provision, it says, if you want to talk to me privately, I cannot guarantee I won't share the information with the other person in the engagement. And so if a conflict arises, I may have to tell you to get separate counsel. It happens. Married couples are encouraged to share things with you fully, but at some point they may need separate counsel, and that's okay. You just have to be able to recognize when that happens. And capacity. If any of you have done estate planning before, you may have a sense of the difference between a person who is capable of seeking out advice and following direction and making plans and executing documents, and someone who has some trouble with those tasks. Estate planning in particular can involve a lot of elderly people and who need supports for various things. And your job as the attorney is to figure out if they're capable of understanding the contents of the document, capable of entering into the document. This is a summary from the Assessment of Older Adults with Diminished Capacity, a Handbook for Lawyers, which was published in 2005. This talk is not long enough for me to get into an exhaustive explanation about capacity, but what I find interesting is the tiers of capacity required for estate planning. So this is actually a list in order from the highest level of capacity needed to the lowest level of capacity needed. It's not alphabetical. The top of the list is contracts. It's a variable level of capacity. The person entering the contract must understand the nature and effect of the act and the business being transacted. What does that mean? It could mean anything. It could mean you're hiring a lawn care person and you understand that for $40 a week, the lawn care person is going to come and cut your lawn and you'll pay them. That's a contract. Or it could be selling a multi-million-dollar company or negotiating the purchase of a house. It's a variable level of capacity. And the two estate planning documents that are closest in capacity requirement to that are the financial power of attorney and the advanced medical directive. The last on the list is the will. To make a will, you need essentially the lowest level of capacity. You need to understand what you have, who are the natural objects of your bounty. In other words, if you have descendants or siblings or parents who want to have benefit from your estate, and interrelate those things to make a disposition of property according to a rational plan. So the highest level of capacity in estate planning documents is needed for a power of attorney. And it is so important to be able to recognize you need to have a private meeting with your client. That person needs to be able to articulate their wishes. They need to show you that they understand the impact of making a contract, the impact of designating someone to make their financial decisions for you. And they need to understand the follow-through necessary. You are not clinicians, and nobody is expecting you to do many mental exams or more in-depth assessment of cognitive capacity. But have a private conversation with people. And in estate planning, you often have two private conversations, and you can see that person's capacity over time. And if you have any questions, you can say, time out. I need to talk to an attorney mentor to figure out what I do next about this, because it happens all the time that you have questions about somebody's capacity. Talk through it with somebody who has that experience and get a sense of what things you can do next or what questions you can ask before setting a person up for failure or a family up for a fight. Estate planning involves appointing agents to make decisions for you. There we go. So an agent is someone you choose to step in to act on your behalf when you cannot act on your own. In estate planning, we appoint agents under power of attorney to make financial decisions for somebody, for you. An agent under a healthcare directive to make healthcare decisions for you. And then you can also have agents for specific transactions. So somebody doing something for you under a writing. Agents and other fiduciaries have duties. This is not an exhaustive list of duties, but when you're counseling clients in estate planning and you're talking about these various roles, you need to be able to explain to them the skills their agent should bring to the table. Clients often say, oh, I have a child, and because I have a child, I am going to name my child as my agent. That's not always the wise decision. And as a counselor, you are going to be in a position to explain what the role entails, explain what skills are needed, and explain that the person stepping into that role will need to observe these duties. So a fiduciary is a person who holds a legal relationship of trust with another person. A fiduciary has a duty to act in the best interests of the principal. So in a financial power of attorney, the principal names an agent, and then the agent, under law, is obligated to act in the best interest of the principal. The best interest, the fiduciary obligations include the obligation to do lawful acts. Well, that seems pretty obvious. You don't want a fiduciary who will break the law related to your assets. The duty of care, the duty to make careful decisions with regards to your assets. The duty of fair dealing. You want to make sure somebody's able to differentiate between fair deeds and unfair deeds. The duty of good faith, the duty of inquiry. This is a real pickle. You have to have an agent who's willing to be curious about what's going on. You may have a bank account, and bank statements get delivered to your house, and that is obvious, and your agent will know that this is your bank account. But your agent's also going to have the duty to inquire. You have other assets. Should that person look further? And that is a fiduciary duty. The duty of loyalty. I think this is the most important one, and certainly when I talk to my clients about, my new clients about before we do these documents, in particular the financial power of attorney, because that person must be able to put your needs ahead of their own. That person must be able to be loyal to you. When weighing options, choose the option that is in your best interest, and not be swayed or persuaded to do something that might benefit him or her. So an estate planning attorney has to think through, what are all these duties? How can I explain it to the client and help my client make a decision to appoint somebody who is best suited for the role? Any questions now? Do we have any questions that came up on those practice tips or ethics considerations in the chat? Okay. So now that we've slogged through that, and I appreciate your patience with me, we'll get into some of the meat and potatoes.
Alice, actually, can I have a question? Please. I was thinking about when you were speaking. So you talked about the conflict of interest waiver that you have with a married couple side. If you have a child or someone who the client wants to be a part of the consultation, you know, you talk to the client privately, you've gotten there, okay, you kind of explained what the consequences are. Do you have the client, you know, sign anything in particular, like allowing that person, you know, I guess stating that they're waiving confidentiality or anything of that nature?
I actually don't.
We don't either. I was just kind of
I could see where that would be helpful.
Yeah.
I say it out loud. So first I pick that person out so I can have a private meeting with the client. Maybe it's 20 minutes, maybe it's an hour, it depends on how the meeting goes. And then I ask them, do you want me to bring that person back in? And if they come back in, is there anything I shouldn't share with them that you want to keep confidential? Or most often the case is, do you want me to explain what we talked about? Because they want that person to understand what the heck's going on. And often the person who brings them is going to be the fiduciary. And so it's helpful to the client, to the fiduciary, to hear what the expectations are and what's going to happen. But I don't have to sign anything.
Okay. Yeah. Thanks.
Sure. So advanced medical directives, we're going to talk about this document and a couple other documents. And I just want to point out that a client, when the client comes in to meeting or comes into MVLS to triage, the client may say, I want my child to have my house when I die. And that's the extent of the client's desire for representation. But you, as the counselor, are going to talk about all three of the documents we go through today: the advanced medical directive, the financial power of attorney, and the will, because everybody over the age of 18 needs all three documents. You will be doing a service to your client to have that conversation and at least offer these options. Getting an attorney through MVLS for estate planning is like Cinderella. When the Princess Footman arrives at Cinderella's house with the glass slipper and tries to wedge it onto the feet of the stepsisters and fails, and Cinderella emerges, and the footman places the glass slipper on Cinderella's foot, it's a magical moment. You are the footman. The glass slipper is the estate plan, and Cinderella is the client. Not everybody gets the gift of volunteer representation for estate planning. You are bringing a magical gift to a client in need, and you want that slipper to fit. To get the right fit, you need to ask a bunch of questions, you need to be curious, and you need to offer the standard of care for estate planning. And the standard is an advanced medical directive, a financial power of attorney, and a will, plus or minus some other things. So be the hero, be the footman. Okay, so we're going to turn our attention to advanced medical directives. And there are two images on the screen right now. On the left side of the screen is an image of the Maryland Advanced Medical Directive. Everyone over the age of 18 needs an advanced medical directive. And as a matter of public policy, the state of Maryland has decided that it is so important that they actually have an advanced medical directive on their website. So the Maryland Attorney General's website has the document, that's the image of which is on the left of your screen. It's a multi-page document. I'm not going to ask for a show of hands, but think to yourself, do I have an advanced medical directive in place? And if the answer is no, seize the day. Today's the day. Go to this website, print off a Maryland Advanced Medical Directive, complete it, sign it in front of two witnesses who also sign it, and then next time you see me, the answer will be yes. There is no impediment to everyone in this room having an advanced medical directive, and you should do it as soon as possible. No one is promised tomorrow. Yes?
Maybe you will cover this at a later time, but when you have this documentation, how can the hospital and nurses know
Great question.
No, imagine you carry this procedure all the time.
Great question. Thank you. Actually, that's a wonderful question. The question is, how does anyone know that you have an advanced medical directive? And so I'm going to answer your question, and then someone has to remind me to get back to the other point that I've just remembered that I meant to say. Nobody knows that you have an advanced medical directive unless you tell them. So we live in an era of patient portals, and you can scan your advanced medical directive and upload it to your MyChart or your LifeBridge patient portal. That is a way to get one hospital system to know. You could do it if you go to doctors at two places, you could upload it to two patient portals. You should give a copy to the person who serves as your agent. You can give a copy to your primary physician. You can keep a copy in your glove compartment if you wanted to. Most people don't. It is only, any of these documents is only as good as how you disseminate them, how you get that information out. So that is really important. The other thing I wanted to say was, with the advanced medical directive and the financial power of attorney, and we'll get into more details of both of them, but with these documents, The absence of the document is the crisis. So before we began talking today, we were sitting here in this room and talking about guardianships. And guardianships are also a part of an estate planning attorney's practice. And a guardianship is needed if someone becomes unable to make or communicate decisions and they don't have these documents. So if you have an advanced medical directive, you're naming an agent to make healthcare decisions for you, and you're giving them a framework for making those decisions. If you don't have an advanced medical directive and you become unable to make or communicate your decisions, and a crisis comes up and a decision must be made, it is possible your loved one will have to go to court to become a guardian of your person. If you have a financial power of attorney and you become unable to make or communicate your decisions, your agent named in that financial power of attorney can step in and make financial decisions for you. If, on the other hand, you fail to put in place a financial power of attorney, a crisis happens, you become unable to manage your affairs, your financial affairs, your loved one may have to go to a court to become a guardian of the property for you. Becoming a guardian of a person or guardian of the property is an expensive and time-consuming process. It takes 2 to 4 months, and it may, if you have an attorney, it may cost $2,000 to $5,000, depending on who's seeking guardianship, what the circumstances are. It is not a quick process, and there are serious expenses. Not only does the person seeking guardianship over you pay for an attorney, but then you pay for an attorney to represent your own interests, even though you're incapacitated, before the court. So there are 2 attorneys that are being paid out of your money, which is very upsetting to people who don't like attorneys. So the best way to avoid that time-consuming expense is to do these documents in advance. Yes?
So would you suggest for whoever you're naming as your power of attorney or the person in place with advanced medical directives to be the same person or different?
Great question. So the question was, if you have someone you trust, can they be the healthcare power of attorney and the financial power of attorney? The answer is yes, but there are different skill sets. So the answer may be no. Someone who's good with money and has the ability to be loyal to you and apply your best interests with regards to your finances might be real squeamish and not be comfortable making your healthcare decisions. So you pick from your bench of different people with different skill sets to find the right person for that role and the backup to that role. So this, again, on the left side of your screen is an advanced medical directive. This is a Maryland form available on the Maryland Attorney General's website. If you don't have one in place for yourself, you're going to do it today. You can email me and say, I did it, and you'll be really happy. On the right side of your screen is Maryland Medical Orders for Life-Sustaining Treatment, a snapshot of their website. And I bring this up because these things do different, take on different roles for people's medical decision. And I just want to point it out so that you are aware of these 2 elements of healthcare advanced planning. An advanced medical directive is a written appointment of a healthcare agent, sometimes called a proxy, a healthcare proxy. It includes written authority for the Health Insurance Portability and Accountability Act, HIPAA. It includes an end-of-life care framework, also known as a living will, in case your agent has to make decisions for you about medical decisions. The Maryland Advanced Medical Directive includes organ donation instructions and funeral decision-making authority. So the Advanced Medical Directive names somebody, provides a framework, gives them the HIPAA authority to talk to your clinicians, tells them what to do if you're nearing the end of your life with regards to your organs, and also you can name someone to make financial funeral decisions for you. Fun fact, as soon as you die, the financial power of attorney and healthcare directives cease to operate. So funeral decisions, if you're dead, that becomes a bit murky. Who's able to make those decisions? If you put it in the document, that's who. So it allows you to make those post-death authorities as well. A Maryland Medical Order for Life-Sustaining Treatment is an actual medical order signed by a physician, nurse practitioner, or physician's assistant providing portable and enduring instructions from emergency medical technicians or other providers who encounter an unresponsive client in an end-of-life scenario. I've fallen and I can't talk. In the absence of a valid MOLST form or an EMS DNR order, patients who are unable to communicate their healthcare wishes will receive the full scope of interventions permissible under the Maryland EMS medical protocols, including aggressive life-saving CPR. What that means is if you have a loved one who is elderly and living alone or in an assisted living or in a nursing home, and they don't want aggressive life-saving CPR, that's your tool. Maryland Medical Orders for Life-Sustaining Treatment. It's a medical order that resides in their chart or is taped next to their front door or on their refrigerator, where the EMTs know to look, and they see a doctor says no CPR, and that person will be allowed to die without a broken sternum. The Advanced Medical Directive, on the other hand, is a document providing an agent and a framework for decision-making that you don't know what the decisions are going to be in the future, and you just want to have those, you want to have someone in place to make decisions if you become unable to make or communicate your own decisions. So these are, the next few slides are some excerpts from the Advanced Medical Directive that's available on the Attorney General's website, which you all have already promised to complete today. You select a healthcare agent, name, address, and telephone number. How will somebody know who your agent is? If they have this, they'll have the phone number of the person who called them. So make sure that when you're working through this with your pro bono client, you gather that information to put on the form. It's not a question of, oh, I'll do it later. Let's get it down now while we're together. HIPAA authority. I do an Advanced Medical Directive that's different than this, but it has HIPAA authority too. And I want to impress upon you, has anybody heard of the document 5 Wishes? Yeah. 5 Wishes is a campaign. It's a national campaign. It's a website. You can print out forms, and it has many of the same elements of an Advanced Medical Directive. It's in simple language. People do like it. Lots of churches and other community organizations promote the 5 Wishes. Doesn't have HIPAA. Why do you need HIPAA authority? Anybody? Any lawyers in the room? Why do you need HIPAA authority? Please.
Maybe your loved ones can go to another hospital to get your record.
Right. So one reason for HIPAA authority is if you're transferred from a hospital to another medical facility, who authorizes the transfer of those medical records? Someone needs the authority to do that. Another reason, just for UPI attorneys, is to be able to request medical records in the event of an injury. So if somebody becomes injured and becomes unable to make or communicate their own decisions, a PI attorney cannot gather information to make a case without HIPAA authority. So it's important, and it is not in the 5 Wishes. So even if your client says, oh, I have a 5 Wishes, I still think you need this. The living will, the end-of-life care framework. These are pretty standard instructions, but they are not sent from on high. A client can write their own instructions, and sometimes clients do. So the Advanced Medical Directive that the Attorney General provides has certain instructions. What happens in the event of a terminal condition? What happens if I'm in a persistent vegetative state? What happens if I'm in an end stage condition nearing the end of my life? These are the 3 levels of care I'd want. But if a client says, you know what, these don't speak to me, I want to write my own, they can write their own. This is not magical language. But it does go on for several pages. So you can walk through this afternoon when you do your own Advanced Medical Directive. Here on this page, it says, G, effective state of preferences. I realize I cannot foresee everything that might happen after I can no longer decide for myself. My stated preferences are meant to guide whoever's making decisions on my behalf and my healthcare providers, but I authorize them to be flexible in applying these statements if they feel doing so would be in my best interest, or follow my instructions as written, even if you think some alternative is better. this is a conversation with a client. This is, sometimes you have to walk through that. So you want to read this document and understand it before you work with your pro bono client so that you can provide some advice and reflection. Organ donation. I tell my clients, if you're an organ donor on your driver's license, let's make this match. If you're not an organ donor on your license and you want to donate your organs, update your license. Because this isn't magical. This doesn't solve all problems. This works in a situation with your loved one making decisions, your physicians making recommendations, your documents saying this, your other documents saying this. You want things to tick and tie as much as possible. So that's why we do planning in advance. And then the funeral instructions. If you don't want your healthcare decision maker to make your funeral instructions, name someone else. If you want your, this set of people to make your decisions and this set of people to make your funeral plans, gives you a place to do that. Funeral instructions, cremation, just a side note. In Maryland, if you want to be cremated, you should write it down and have that writing witnessed by 2 people. This is witnessed by 2 people. So if you want to be cremated, write it down because this is witnessed by 2 people. If you don't do that, it is really up to the person who is making those decisions to make that. Yeah.
So I have a couple of questions. One is most and advanced medical directive, they don't overlap.
So that's a great question. The question is, the advanced medical directive and the MOLS, do they overlap? They don't. So you can have both of them. One names an agent, provides a framework, does, addresses organ donation, funeral planning. The other is, has anybody here seen a MOLS? Medical Orders for Life-Sustaining Treatment. So there's a whole website. The MOLS is a 2-page form, and again, signed by a clinician because it's a medical order. And on the 2 pages, it goes through, if I'm encountered in a cardiac arrest, if my heart's not working and someone encounters me, do I want CPR? Do I want advanced CPR? Do I want to be ventilated? Do I want dialysis? Do I want antibiotics for an infection? It is these sort of granular details about medical care if you become unable to communicate your decisions. And nobody knows. Nobody knows what's going to get you. Nobody's promised tomorrow, and we have no idea how this will end. And putting in place, the law says, if you are entering an assisted living or a rehab, you have to have a MOLS. The law says someone must do a MOLS for you when you're entering those facilities. I tell my clients, if you are diagnosed with a terminal disease, get yourself a MOLS. You don't have to wait for your doctor to talk to you about it. You can talk to your doctor about it. There is it's actually a 38-page patient instruction booklet online that I print out and I give to my clients. It's a lot, but if you are nearing the end of your life and you don't want your sternum crushed, I would say it's fair to do a MOLS. Have it at your home, have it at your doctor's office, have it available to follow you into a hospital. When you get admitted to an assisted living or rehab, the law says they have to do one, but you and I both know that clinicians are busy, and what they do is one question: CPR or no CPR. That's what they do. It takes them 3 minutes. They ask you, there's no conversation about it, and then they sign it and put in your chart they've met their obligation. But that doesn't reflect the full scope of possibility of the MOLS, and it certainly doesn't reflect someone's full wishes. So I have my clients go through it in advance. I have a woman I work with who's a physician's assistant. She'll sit with the client for an hour and the family and go through it all. And then you go to your primary and you tell them what you want them to do. Yes.
Unrelated question. We sometimes have clients who say, I would like to name all of my children as agents. Can you talk about the pros and cons of putting multiple agents on I guess, any of these documents?
Yeah, so Margaret's question is 1 agent, 2 agents, 3 agents. How do you counsel clients on who should serve as an agent? And it really depends. For financial decision, we're going to take a break, after which we're going to get into the financial decision making. But for healthcare decision making, it is possible to have multiple agents. You can name one person, two people, three people. I had a family named 6 people. You have to have a framework in place for disagreements. So if you're naming multiple people, do they have to agree unanimously, or is majority okay? If they have to agree unanimously, what's the framework for an impasse? Do you have a second person, a separate person to do the tie breaking or to step in at that time? So you might name 3 children and they must make decisions unanimously, but if they can't, then I want my sister to step in and be the decision maker. Is that setting families up for a nightmare? Yes, but families are already a nightmare in large form. So you have to counsel the client on these options, and you have to give them reasons to do this, reasons to do that. But at the end of the day, it is up to them, and that's what hospital ethics boards are for. When families can't agree, there is a group of people in the hospital who then navigate that, and it's a real big mess. But it's, at least you have someone in place. Yeah.
So I just noticed that advanced medical directive there's a portion for funeral arrangement.
Yeah.
Do you also include it in the will? And if you do, then what happens if they don't?
Great question. So the question is, there's funeral directions in the advanced directive, and also sometimes people include them in the will. In my experience, the will is not likely to be seen or read until after someone dies, because that's when the instructions take effect. Funeral instructions should be part of the healthcare document, because that's more likely to be read in the end of life scenario when you're actually thinking, oh my gosh, mom might die. Here's what she would want. The gold standard is for an individual to make his or her own funeral arrangements. So many people can't stomach it. They don't have the heart to plan their own funeral. But if you have a client who has the foresight and the fortitude to do that, the gold standard is to have them go, set up their own funeral, buy their own policy, get it in place, and then no one has to worry about it. Yeah. So thank you for sticking with me during the practice tips and advanced medical directives. We're going to jump into financial powers of attorney. Just to remind you, at the beginning of the talk, we talked about fiduciary duties and capacity for entering into these estate planning documents. The financial power of attorney is the document that requires the highest level of capacity, and the agent is someone who will have access to your finances while you're living, while you still need your assets. So when I counsel clients on choosing an agent for financial decision-making, this is the most important document, and it is the most scary document, because somebody is going to have the authority to navigate your finances while you're still living. And people get very nervous about it. They say, oh my goodness, I don't want anyone to have access to my assets while I'm living. The problem is, if you don't do a financial power of attorney, as we touched on, and you become incapacitated, your loved one has to go to court. And that's time consuming and expensive. But also, if you have more than one person who cares about you, there's no guarantee they will agree who should be the guardian of your property. And then you may be in a contested guardianship situation, which is worse than a regular guardianship situation. So to the extent you can convince a client that doing a financial power of attorney in advance is cost effective, it's cost effective because it's free to do it here, and also saves their family time and money in the long run, you should encourage a client to do this. Yes, question.
Does this have any bearing on whether an individual is a citizen, a foreign individual, or possibly a legal immigrant?
Great question. The question is about someone's citizenship status. And these are contracts, and there's no impediment to someone entering into this type of agreement. There are some nuances in estate planning, in asset transition at death related to citizenship that are beyond the scope of this talk, but there is no impediment to somebody who's not a US citizen to making an advanced medical directive. There's no impediment to someone who's not a US citizen to making a financial power of attorney or a will. If you do a lot of planning for people who are not US citizens, you should get specific training on that so that you're understanding the nuances of the laws that do apply. But for most people, not a big deal. There are different types of financial powers of attorney, and I've just listed a couple variations here. There's a limited power of attorney and a general power of attorney. There's a springing power of attorney and one that's immediately effective. There's a durable power of attorney and one that's only effective during the principal capacity. For the purposes of this conversation, I'm going to focus on a general power of attorney that is immediately effective and durable. In 2010, Maryland passed a law creating a statutory power of attorney. So all of you, make sure your powers of attorney and the powers of attorney of your loved ones are all created after 2010. Because if they're older than that, two things. One, they probably don't comply with the law. And two, they are stale. They're 13 years old. Get a new one. Powers of attorney should be refreshed every 5 years. When you're counseling your low-income MVLS clients on powers of attorney, you are going to be offering them a general power of attorney that is immediately effective and endures even if they become incapacitated. And that's the gold standard. That's what everybody needs. If they're nervous about it, we can have further conversations, talk with a mentor. Okay. So I have to re-engage here. There we go. So again, the power of attorney is like a contract. It requires the highest level of capacity. It's a broad and sweeping document. It gives somebody the authority to stand in your shoes for financial decision-making. If the capacity threshold parallels that of contracting, the principal must have a higher level of competence than for most other estate planning documents. We've all talked to people who have varying levels of capacity. When you're working with somebody who comes in because they want a will, almost everybody who is able to do a will is also able to do a financial power of attorney. So it is a tool you have in your toolbox. Your clients, your paying clients and your pro bono clients, every single one of them need this document. You need this document. The Maryland statutory form financial power of attorney. Let me just take a pause. We talked about how the Maryland Attorney General website has the Maryland Advanced Medical Directive. It's a packet, you print it out, you complete it in your handwriting, you sign it in front of two witnesses who also sign having watched you sign. That's your Advanced Medical Directive. The Maryland Code also has a power of attorney. In 2010, the legislature created the statutory form power of attorney. There's a limited statutory form. There's a broad statutory form. I caution you against using the word general because it's not technically a general power of attorney. These documents are not beautifully packaged on a website like the Advanced Medical Directive. So if you Google Maryland statutory power of attorney, you'll be confronted by many ads and sponsored websites offering to sell it to you, which is fine. You can buy it online. That's great. If you want to save some dollars, you copy and paste out of the code and create your own Word document, or if you are a dinosaur like me, a WordPerfect document. It is copied and pasted out of the code.
We also could give it to you through MVLS.
Do you have it?
We've done that. We've done the copy and pasting.
Oh,
Saves
good.
a lot of time.
Good. Yes, it does save some time.
Yeah.
The law says if a financial institution is presented with a power of attorney in substantially similar form to that of the statute, they agree to accept it. So you have a high degree of confidence if you've copied and pasted properly out of the code, that is substantially similar to the form in the code. You have a high degree of confidence the financial institution will accept it. All of estate planning is like gambling, rolling the dice. You don't know what's going to happen with an estate plan until many years later, which makes it an exciting area of practice. I am always hopeful that that my clients live a long time, and I never find out if my work was successful. But a financial power of attorney is kind of interesting gamble, because once you need it to work, it's usually too late to do a new one. So you want to do the best job possible. You want to be thorough. You want to copy and paste really carefully, so that if that agent has to take your client's power of attorney to a financial institution, it works. And you don't know if it works until later. The statutory form financial power of attorney has a preamble, and it says you should be very careful in deciding whether or not to sign this document. The powers in this document are broad and sweeping. This authorizes someone else to manage your assets while you're living. This is the most important line here. You should select someone you trust to serve as your agent. When you're counseling clients, they are going to say to you, well, I want this power of attorney because you told me it's an important thing, but I don't want it to work until I have a stroke. I don't want it to work until I really need it. Everybody says that. And you must be prepared for that conversation, because if you're trusted, if you pick someone you trust, it can be effective immediately because you know that person's not going to steal your assets. If you pick someone you trust, it can be effective immediately because you know that person is not going to go behind your back and misuse it. If you are picking someone you don't trust, stop. Go through the conversation again. If you're picking someone you don't trust to have access to your assets while you're well and healthy, that is definitely not someone you want to have access to your assets when you've become incapacitated. So you must think through with your client, what's the skill set? Do they have the acumen to manage your finance? Do they manage their own finances? Do they have the ethics to be loyal to you and to use your assets only for your benefit? Are their own financial affairs in order, or do they owe money to their bookie? Are they going to have a desire to access your assets for their drug problem, for their gambling problem, for their alimony? These are really important things to think through with your clients, because you should only select someone you trust implicitly. The power of attorney we're going to talk about is the one that is broad, not limited. And again, I caution against using the word general, because it is not technically a general power of attorney, but it is like many, many pages, and it gives many, many instructions. So it's like a general power of attorney. Yes.
You have a question on the Zoom, which is there a drawback to making it springy?
Oh, sure. And the question is there a drawback to making it springing? And just to go back, springing versus immediately effective. And an immediately effective power of attorney allows somebody access to your assets right away. No hurdles to jump over. A springing power of attorney, I think that person might have, oh my gosh, she actually queued up my question, my slide. A springing power of attorney only comes into effect upon a certain circumstance. And this is a choose your own adventure. These are examples, but these are not exhaustive. So a client could say, I only want it effective upon the written certifications of 2 physicians, or 1 physician and 1 licensed psychologist or clinical social worker, that I'm unable to make or communicate responsible decisions concerning my finances. Does that language ring a bell for anybody? Sound familiar? That's the guardianship language. That is a really high hurdle. You've got to get 2 clinicians, a physician and at least another physician or psychologist or social worker, to write down that somebody has become unable to make responsible decisions concerning your finances. How are you going to do that? If your loved one is at home but can't make it to the bank, how are you going to get 2 clinicians into that house to make this writing? That's really hard. The next one says, this power of attorney is effective only upon the written certification of my treating physician that I'm unable to make or communicate responsible decisions. A lower hurdle. There's only one physician needed, but what is a treating physician? What does that mean? Is it your marijuana doctor who says that you have headaches? Maybe. Is that your primary care doctor who you see once a year but hasn't seen you for this particular issue? Who knows? So it's a little vague. And then the third option, these are just examples. This power of attorney is effective immediately as to the first person I name because I really trust that person, but only effective as to my successor agent upon a subsequent circumstance. My counsel to my clients is make sure everybody on page 1 of that power of attorney is someone you trust absolutely. If you don't trust anyone, well, then we have to have a different conversation. But to name an agent for finances is to give somebody the keys to your car while you're well and healthy. And you want to have somebody in your circle of trust who can do that. Sometimes people only have one person. Sometimes the power of attorney only has one name. I prefer that people have at least two, a primary and a successor, because that extends the life of the document. If something happens to the first person, you have a backup. But I advocate against springing powers because when the crisis pops up, do you want your named agent to have to go circle up? It could take weeks to get 2 clinicians or even 1 clinician to return your phone calls. So I advocate against springing. Yeah.
So with the springing, do you have to use those 3 or can you make up your own?
Choose your own adventure. My kids agree and deliver writing to me that says I'm unable to make my, because your kids, if they're going to write something down and deliver it to you, they're going to have to mean it, because otherwise you're going to be angry that your kids have said that you're unable to make your own decisions. So this is a financial power of attorney example language in trusts. It's the same issue. If I'm the trustee of my own trust, there might come a time when I can't do that anymore. So in a revocable trust, I have a paragraph about this, and sometimes it is my kids. You know, these 2 people agree amongst themselves and also deliver something to me saying that we're taking over. If you're in a coma, it's easy. But if you're just have some dementia and you're cranky, that could be a big fight. So it's a delicate thing. Any other questions about springing?
No other questions in the chat.
Okay, super. The word durable versus non-durable. According to the code, all powers of attorney are durable unless otherwise provided, and it's intuitive. The purpose of the power of attorney is for it to work when you become unable to make your own decisions. But for whatever reason, you could make it only in effect until you become incapacitated. That just seems so weird. But you could do that if you wanted. Execution formalities of a power of attorney. We do have an update to the law, something called electronic presence. So a financial power of attorney must be in writing, signed by the principal or some other person for the principal, in the presence of the principal and at the express direction of the principal, acknowledged by the principal before notary, and attested and signed by 2 or more adult witnesses who sign in the presence of the principal and in one another's presence, electronic or physical. Please understand, I paraphrase the statute. If it appears to be clear writing, it's because it's not statutory language. But the idea is, as the law has evolved and our technology has evolved and we've all navigated a pandemic, it became clear there had to be other ways of getting a power of attorney done. And so, they modified to permit electronic presence. I still supervise all my executions because humans don't follow directions. And it doesn't matter if they're written directions or oral directions or, cartoon directions, they just don't follow them. So I like to lay eyes on my clients when they're signing, and I have the privilege of working in a firm where we have lots of notaries and witnesses. So that's what I do, but there are alternatives. Yeah, please.
So witnesses or should it be kind of like a neutral, unnamed party?
That's a great question. So the question is, who's permitted to be a witness? And it varies in these documents. So for an advanced medical directive, and I do not have a photographic memory of the code, but you cannot be a witness to an advanced medical directive if you are named as the agent or taking under that person's will, obviously, because then you have some motivation to pull the plug. So an advanced medical directive is actually the most restrictive document on who's permitted to be a witness. Financial power of attorney, you can be a witness if you're the named agent. There's no restriction against it. We don't do that in our office because we want a high level of separation between the witnesses and the principal. And a will, we're going to get into that. Anybody can witness a will. The person named to receive a gift, as long as you're over the age of 18 and you yourself have capacity, you can be a witness to a will. So if you are going to be involved in this area of practice, I would advise reviewing execution formalities. I do want to take a moment to put a plug in. If you like estate planning and estate administration, if you think this is an area of practice you want to get to know more about, the MSBA is publishing a practice manual. They republish it every few years. There is a class in 2 weeks I am teaching. It's a 2-hour class, the same topic, but different aspects of estate planning. So if you're interested in this, buy the practice manual and attend the talk or watch the talk virtually to get more in depth on certain aspects. And I get into a little bit more about execution formalities there. Anybody know why a financial power of attorney might include a special instruction for gift giving, even for low income clients? Anybody have a sense of why a financial power of attorney would permit an agent to make gifts of the principal's property?
They might have to pay off some debt.
Maybe to pay off debts?
They might have like one expensive thing, like a engagement ring.
Sure, and to transition assets from owned by the principal to owned by a person who's receiving under the estate plan? Yeah. Yep.
To make sure the
One of the Stevens got it. To make sure that a client can qualify for medical assistance. So medical assistance is a means tested benefit. If a Marylander has to go into a nursing home and a nursing home costs $10,000 a month, those assets are going to go pretty quickly. Gift giving power in a financial power of attorney permits an agent to make gifts of the principal's property for the purpose of spending down their assets to qualify them for medical assistance. So the statutory form power of attorney does not include gift giving. Gift giving is above and beyond the duties or permissible actions of an agent for finances. It's giving away money, and you've just said the agent must use the principal's assets for his or her own benefit, for his or her best interest. So if you want an agent to be prepared to do a Medicaid spend down to qualify the principal for medical assistance if he or she needs to go into a nursing home, you should include a gift giving instruction. And this is an instruction. It's in every single power of attorney I do. Everybody needs this instruction, but it's the one that people want to talk about most because they're like, whoa, time out. Why would I want somebody to give my money away? This is my money, it's for me. And the purpose is to get your assets spent down to qualify you for medical assistance while preserving as much as possible for the spouse that's going to remain in the community, or for your grandchildren, or making sure your house can be transferred so those folks continue to have a place to live. Medical assistance, the state of Maryland, the Department of Health, they have an algorithm, they have a calculation that says, oh, if you give all this money away, then there's a penalty for that. they take care of the math. Your job is to make sure the option is available. So this is, I didn't write this, by the way. This is copied and pasted out of the limited statutory power of attorney. So this gift giving instruction, I used Control C and Control V into my power of attorney because the legislators wrote it, and we all know that they're exceptional drafters. My wife is a bill drafter for the Department of Legislative Services, so it's an ongoing joke. This was the planned break. Aren't you glad we broke earlier? I'm going to skip through this and we'll break again in about 20 minutes for a stretch. So that was financial powers of attorney. Any questions about financial powers of attorney? It is the most important document you can do for a client. It is the highest level of capacity required to do that document. You get a cheat sheet because the legislature wrote it for you. If you are engaged to work with a low income client through MVLS and they say, I just want to deal with my house or I just want a will, please have the conversation with them about putting a financial power of attorney in place to avoid the expense and delay of the appointment of a guardian of the property if they become incapacitated. Yes.
Are there best practices for executing copies?
Oh, thank you. Wow. We got a question from the audience that is an opportunity. Any benefit to executing multiple powers of the copies of the power of attorney? And the answer is yes, because when you need it to work, it's too late to do a new one. So my best practice is every client gets 2 original financial powers of attorney plus an additional original for every parcel of real property they own. So we do have a ringer, I think, in the class with us today who does recordation in the land records. And when a deed is executed by an agent under financial power of attorney, that financial power of attorney, the original, must be recorded with that deed. So if you only have one original, it means giving up your only original to the Department of Land Records. And I love those folks, but I don't trust them. So you want to know that you've got a backup original. The Land Records Department will send you the original back, but if they don't, or if it gets lost in the mail or whatever, you have a duplicate original. Another best practice, the statutory forms are fantastic and all of my clients get them. I have pages of special instructions I add to that statutory form, depending on the client, depending on their assets. But the best practice is for that person, the client, to carry the statutory form power of attorney into their financial institutions and say, this is my power of attorney. Please, scan it into your system, have your legal department review it, add my agent's name to my accounts. Because if your client does that while they're well and healthy, then upon incapacity, their agent doesn't have to scramble, find the original, try and convince Bank of America that you really meant it. They'll have access to the account right away and they'll be able to handle your affairs right away. So duplicate originals make sense, plus an additional original for every parcel of real property, just in case. And have that person walk into the financial institution with the original and instruct the financial institution to reflect this agency in their records. Yes.
There's one other question in the chat. Can we discuss the new provision effective October 1 of the financial power of attorney?
No, we can't. I haven't digested it yet. Super sorry. What is the new provision? Maybe that person can discuss it. I don't know.
So hopefully they can hear us. I don't know if they can hear me, but if you want to put anything in the chat, self-dealing, they say. Self-dealing. I would say that is perhaps something we can follow up on after the presentation and send something out to members of the cohort.
That's a great. So when I say copy and paste the document out of the code, I mean copy and paste the one that's available now as of October 1, which we're in the process of creating our WordPerfect form for that. Self-dealing, I am not familiar with the details of the statute while we're standing here, but Self-dealing is a fiduciary duty. We did talk about it in the pro tip section, and it my hunch is it's going to permit an agent to do self-dealing if you allow them to, because there are circumstances where your agent is acting on your behalf but also has an interest in the asset that they're operating on. But you should, if you 5 years ago copied and pasted and created your statutory form power of attorney, do it again now to include those additional provisions. And the MSBA practice manual chapter rewrite now includes a whole section on fiduciary duties, thanks to our law clerk, Elizabeth Pentikis, who will be an attorney in Maryland next year. She did a lot of research into fiduciary obligations in Maryland, and so that is included in the chapter, in the practice manual chapter now. Any other questions about financial power of attorney? Super. So now we're going to talk about planning for asset transition after death. Low income does not mean lower stakes. Lots of people, everybody here will die. Sorry. Sorry to be the bearer of bad news. Every single person you encounter must or should contemplate what happens to their stuff after they die. It's just part of living. And we're heading into the holiday season. You are going to have conversations around the table with your family about guardianships, about powers of attorney, about healthcare decision making. These are things that naturally come up when you gather with people who you love. They tell you about their health. They tell you about issues they've encountered, and you can do your issue spotting as a practitioner. You know, what can I suggest? What can I talk about to make this burden a little lighter on my loved one? When you're doing it for an MVLS client, you just bear in mind that what they have is so precious, and it needs to work. This plan needs to work. People are counting on them for financial assistance, for housing. If something happens to your client, there are people whose lives will be impacted. And so it's a high stakes process, and you have all the tools you need. This talk, the forms, access to mentor attorneys, you have everything you need to make a great plan, to make that glass slipper fit perfectly. When we talk about asset transition at death, we talk about probate and non-probate. And here you're going to see this red ball a couple times. Everything that someone owns that's taxable to their social security number is part of their total estate. That includes assets that they put into separate trusts that are still taxable to their social security number. Assets that they own in their own name without a co-owner, without a beneficiary designation. That includes assets that are passing outside of their estate by beneficiary designation or contract, even assets they don't get any value from. For example, term life insurance. All of that is part of their total estate, and all of that is in the scope of the work that you're going to do for your clients. Only part of it will be part of their probate estate. And for some people, it's nothing. Sometimes nothing passes through probate. Nothing passes subject to the administration, public administration through the Register of Wills. So the total estate is everything someone owns or controls. Only a part of it may be subject to probate. Common assets you will encounter in low-income planning through MVLS: a house, a car, a checking account, life insurance, house contents, maybe a savings account. These are the things that matter in estate planning. I'm going to pause here for just a second. Little anecdote. We had a client, a longtime client of one of my law partners pass away. And he was the beneficiary of this, let's say $10 million of trusts that he has no access to, but he gets income from. He can't control it, but he gets income. That's great. He himself had about $3 million of assets that he could pass to his children. controls the disposition. One of his children is in financial need. And even the best laid plans don't always, we can always do better. And to me, that money is not going to be available to that child immediately because it has to pass through probate. And that's a big pain in the tuchus. So we're going to talk about how to get money to people quickly, how to avoid probate, how to tick and tie each of those assets of that individual client to the next owner as seamlessly as possible. That's your job. That's part of what an estate planning attorney does. So the common assets that you'll encounter, house, car, bank, life insurance, tangibles, maybe a savings account. Some people have a second bank account. How do you know what's going to pass through probate or not, or pass outside of probate? Before I get into that, does everybody know what probate, like, am I saying the word probate and non-probate and you have questions about it? Does anybody want further explanation about that?
I guess the non-probate term, it might be self-explanatory, but I mean, I know probate, but
Great.
I've never heard anyone say.
Non-probate, yeah, the not probate. So non-probate means a new owner gets the asset by contract, beneficiary designation, or operation of law immediately. And that's a great way of avoiding the time and expense of probate. So how do you know if a house is going to be in probate or outside of probate? Bueller? You look at the deed. How do you know if a car is going to be going through probate or outside of probate? You look at the title. How do you know if a bank account will pass through probate or outside of probate? You look at the statement. How do you know about tangible personal property? That's a bit more mysterious. Where is it located? If it's located in a house owned by a decedent and that decedent's the sole occupant of the house, pretty straightforward. If it's located in a house owned by the decedent but occupied by other people and the decedent, that's murky. Did the decedent give the contents to the other people? Is some of it the decedent, some of it the other residents? That's a little bit murky. It's hard to plan for. And savings account, look at the statement. Ways to transfer property at death include have a co-owner on the asset, have a contract disposing of the asset upon death, use a will or a trust, a testamentary writing to direct it. That's through probate or outside of probate in the event of a trust, or through intestacy. We're going to walk through all of these things. So to transfer property on death to co-owners, you need to have a co-owner with rights of survivorship. We're going in the way, way back machine to property law, first year. If you have a joint tenant with rights of survivorship, that person will own the property when you die. If you have 3 joint tenants, all with rights of survivorship, then on the death of one of them, 2 are the owners. On the death of the second, 1 is the owner. Rights of survivorship have to be explicated. If it just says joint tenant, that's not enough. Read the document. All of you are too young to have had Dickie Bourne as a professor, property professor. I'm not allowed to swear on this recording, but there's a word here that Dickie would insert. Read the document. It's in there. If you do not access the deed and you are doing estate planning for a client, you are negligent. Deeds are free. You get your little user ID and password on the Maryland Land Records website. Get curious. Look up the address. Look up the property owner. Look at the deed. Find out for yourself. You're the lawyer. You know what it says. If you have trouble, download it. It's free to print it, and send it to a mentor. Say, what does this mean? If you don't do that, you are not doing your job. Tenants by the entireties. That's joint tenants with rights of survivorship exclusively available to married people, and it comes with some additional protections. So tenants by the entireties is a right, includes a right of survivorship. And tenants in common, does that have a right of survivorship? No. So if two people own real estate as tenants in common and one of them dies, that person's half will pass through that person's probate estate. The other person owns half the property, and now a personal representative of the estate of the deceased co-owner owns the other half. That's complicated. So you want to be able to plan for that, and you can't. Transfers of property at death outside of probate by contracts and beneficiary designations. All of you have these contracts. If you have a life insurance policy, you entered into a contract, and when you did that, it said, who do you want to have get the benefit when you die? You probably filled that in. If you didn't fill it in, the contract says what happens to it. Either the contract says it goes to your heirs at law, or the contract says it goes to your estate. So life insurance passes most of the time outside of probate, but you can mess that up. You can fail to fill that in, and then it might pass through your estate, which just makes it more expensive and time consuming. Retirement accounts, 401k, 403b, SEP, IRAs, all of these have contracts that govern the disposition on the owner's death, and that beneficiary designation is what passes the asset. And so you want to make sure to review those with the client. Many people have life insurance policies because they watch the TV and the TV says get a funeral policy, and they buy a funeral policy. What does that mean? Your job is to figure out what's the funeral policy, what's the beneficiary, how can that be best applied to this client's needs, and make a smooth transition so that when that person dies, the funeral home gets paid and the money goes where it's supposed to go. Many assets pass by contract, deed, co-ownership, and beneficiary designation. So if you're going to do a will for a client, you have to make sure that the will aligns with what these documents say. Look at the deed, look at the bank statement, look at the life insurance designation. Make sure that if they have a wish that they want to put into a will, that there's going to be some money to fund it. If they co-own with rights of survivorship their house with their sister, and their will says, I want my daughter to have the house, what's going to happen? Anybody?
I had a call about this yesterday. The deed is gonna be the one that governs what's gonna happen.
The deed governs what happens. Likewise with life insurance. These calls happen all the time. My dad told me I was getting his life insurance, but now his new wife has it. He died and she has $100,000. How do I get my part? You don't. Sorry, you're out of luck. That was somebody who didn't either lied to his child, which happens all the time, or failed to do comprehensive estate planning with a knowledgeable counsel. Intestacy. Intestacy is where assets that don't pass by contract, deed, co-ownership, beneficiary designation, will, or trust, intestacy governs what happens then. So the state of Maryland has an estate plan for everybody. This is your estate plan. It may not be what you want to have happen, which is why you sit down and make the plan that you want. And if you do it properly and execute in accordance with the formalities, you don't have to have your assets passed by intestacy. But we're going to walk through this because there have been some changes in the law, and I want to make sure that you know what happens. Does everybody here have a will? You don't have to raise your hand, but you can. There is no impediment to you doing your will today. You're going to print out your advance directive and do that. You need 2 witnesses for a will. You might as well do this because in the absence of a will, it can get complicated. Where a decedent is survived by a spouse or domestic partner and no children or descendants of predeceased children, the estate is distributed to the spouse or domestic partner. What? That's new. That wasn't the law last year. Where the decedent is survived by a spouse or domestic partner and minor children, the estate is distributed 1/2 to the spouse or domestic partner and 1/2 to the minor child, or divided among the issue. So if there's at least one minor child of the decedent, then half gets divided among the issue of the decedent and half goes to the spouse or domestic partner. Where the decedent is survived by a spouse or domestic partner and issue, but none of whom are minors, no children are minors, the estate is distributed 100 grand and a half of the residue to the spouse or domestic partner, and the balance divided among the issuer. Where the decedent is survived by issue but no spouse or domestic partner, the estate is distributed equally among the issue. Where the decedent had no surviving spouse or domestic partner or issue, the estate is distributed to the parents. If only one parent is living, it's to one parent. If no parents are living, it's to the descendants of the parents. If there are no living descendants of the parents, then you go up to the 4 grandparents. And if none of them are living, you go to the descendants of the grandparents, and you work your way down. You have to work through 5 levels. It's a lot. Everybody has heirs at law. Yeah.
So if you have a domestic partner, if they're not registered,
Ding, ding, ding.
what happens? They just don't get anything.
Correct. Yeah. So the question is, what is a domestic partner? How does the Register of Wills know who a domestic partner is? And it's a registration. We're going to cover that. So there are 2 ways to prove domestic partnership. If the decedent had no surviving domestic spouse or domestic partner, no surviving issue, no heirs at law within 5 levels of the law of descent, then the estate is distributed to the decedent's stepchildren or the issue of predeceased stepchildren. That's harsh. There are a lot of people who love their stepchildren a lot, and seeing this at the bottom of the list, it really brings into focus the need for a will. Because if you have a child you've raised their whole life but never adopted, and you in your heart you think, well, of course that person is going to receive my estate if my spouse dies before me. They're not. Your distant cousins are going to get it. Do a will. So this is new, the Registered Domestic Partnership Statute. Any questions? So yes.
I think the intestacy part was updated on.
Yes. Yes. That's what I have. These are obviously, this is paraphrased because the code is much more intricate, but this is updated. Is that get something wrong?
Spouse and surviving children from that spouse and just the spouse. And
Correct.
there's also a change. But I don't remember.
So the stepchild, I mean, I have some degree of confidence that this is accurate, but the Stephen brought up the nuance about children from your spouse or children not from your spouse. And in the 3rd bullet here, it says, where the decedent is survived by a spouse or domestic partner and issue who are not issue of the spouse or domestic partner. If you die and your children are also children of your spouse or domestic partner, then the money doesn't go to the children, because as a matter of public policy, the legislature decided that your spouse or domestic partner is likely to take care of your children in the future. But if you have children who are not also the children of your spouse or domestic partner, then there's a share preserved. Did that clarify? I think we're bringing up a good point, which is read the rules. Read the statute and do wills, because you get to do whatever you want in a will. If you live with somebody or have somebody you consider to be a domestic partner, and you want them to get the benefit of intestate succession, intestate gifts, you need to register your domestic partnership. So a marriage is registered because you sign that book downtown. If you get married at City Hall or in the courthouse, you sign a book. There's a contract. You've entered into it. There's a certificate. The same is not true for a domestic partnership. So you have to tell the Register of Wills that you've entered into a domestic partnership. This is complicated, and you need to be aware of it, because we thought we were going to solve all kinds of problems by extending marriage rights to people of the same sex, and everyone can get married. But it turns out there's been an increased interest in not getting married. And so how do you get some of the benefits of this long-term interdependent relationship when somebody passes away? It's by telling the Register of Wills you had a registered domestic partnership. So a declaration of domestic partnership filed with the Register of Wills shall include the full name of each domestic partner, the home address of each domestic partner, the age of each domestic partner, be signed by each party or another individual at the express direction of the party and in the party's presence, be signed in the physical presence of a notary public or before a notary public through communication technology, and affirmed under the penalty of perjury that each domestic partner is an adult, not in another domestic partnership, not married, and in a committed relationship with the other individual. The Register of Wills may refuse to register a domestic partnership if the declaration doesn't meet the requirements, and they can charge money for filing it. So it's really an additional step for the estate planning attorney to make sure there's a writing that accompanies the documents and is filed with the Register of Wills. There is another way to prove a domestic partnership, and we're going to get into that as well. But since you're sliding the glass slipper onto your MVLS pro bono client, you may as well make it fit. If they're in a domestic partnership, make sure that you make a writing to reflect that and register it, or at least counsel them to register it. Yeah.
This was actually, I think this is a question that I missed. That's going back to the last slide. This person's asking about distribution to, and I actually am not sure, I knew this word myself, so one thing, a putative child, so it's someone who's not a step biological or adopted child.
I love it.
Like if there's that child and a biological child.
I love it. Listen, the question is about putative children, and that is beyond the scope of this talk, but it is a fascinating topic. There are statutes that address who is a child, how someone proves to be a child. There are a lot of avenues to that, and that is a fact-rich analysis. So I think the lawyer answer is it depends. But there's a slide much later in this. Can you believe there's much more? There's a slide later that talks about disinheriting a child, and there's no rule against it. There's nothing that says you have to give money to a child, and there's nothing that says you can't cut a child out. So if you're doing planning for a client, inquire and write it down, put it in the will. If they want to treat this other person as a child, if that's in their heart, put it in the will. There's nothing wrong with that. To die intestate means you did not take the time to write it down. And if you didn't take the time to write it down, and you have someone you treated as a child and someone who you created as a child, these people are treated differently. One is treated one way and the other is a stranger. So write it down, and that's your job. And
I have one more question too about the domestic partnerships. Okay, so we
Okay.
have clients with some regularity, unfortunately, who were actually legally married and never got divorced, and that ends up biting them when they get into a situation where the person died. But with the domestic partnerships, I actually don't know the answer to this. So if you're in a domestic partnership and you register and everything, and then at some point in time you're not in that partnership anymore, I assume you have to like go down there and revoke it.
Absolutely. Right. So the rest of the statute, let me tell you, this is like a third of the statute. The rest of the statute goes through that, how to terminate a domestic partnership and make sure the Register of Wills knows that you've terminated the domestic partnership. Yes.
And I'm assuming like if you don't, it's going to be kind of a similar situation.
Oh, yeah.
If you get divorced.
Absolutely.
That person is then going to be set to inherit.
Absolutely. And we are going to talk about the right to elect against a will for a spouse. If they don't like what's in your will, they can elect a share, a statutory share. Estate planning documents are living documents. You must update them periodically if your circumstances have changed, if your assets have changed. Financial power of attorney should be updated every 5 years, which gives you a natural time to talk to your attorney about other things that have changed in your life. Marriage, domestic partnership, birth of children, death of children. These are big things, and they should be, they should trigger the conversation about any changes that need to be made to the estate plan.
Okay, one more question. in the
Yeah.
chat, sorry. Do you register a domestic partnership with the registrar well, even if you create a revocable?
F yeah. Not allowed to swear, but we're gonna get into why you do that, and it's incredibly important. So a living trust is beyond the scope of this talk, but it is a tool used to avoid probate, and it is an important tool in many circumstances. But a revocable trust does not avoid inheritance tax. Thank you for the segue. I'm going to take a moment to talk about inheritance tax now because it does impact many people and many low-income Marylanders. Estate tax is a tax due on the transfer of assets in Maryland greater than $5 million, federally greater than $12 million. That is a vanishingly small part of the population. Inheritance tax, on the other hand, is a 10% excise due to the register of wills from the recipient of assets that they received because someone died, and in some circumstances on transfers made in contemplation of death. There are exemptions, the code goes through it, but I need to make sure you understand 10% is a lot of money. If you leave a friend your house in your will, the register of wills is going to want that person to write a check for 10% of the value of that house before they permit the transfer through an administration account, before you can transfer that house. If the house is $90,000, that is a $9,000 check. Don't raise your hands. Who has a spare $9 grand laying around? Not many people, and certainly not low-income Marylanders. 10% due to the register of wills. I'm repeating that because who has an interest in collecting that tax? The register of wills. That runs their business. That 10% tax keeps their lights on. They are very interested. They are disinterested in reducing that tax. They want to collect it. They want to be able to give their employees paychecks. So that is a real entity that collects it, and it's a real burden. This is a historic inheritance tax chart. You do not have to memorize it, and I think you can, Stephen has made this available, the whole thing available.
We will after the presentation.
Okay, yeah, so this is something, oh my gosh, I wish I'd said that at the beginning. All these nice people are taking notes. You will get these slides. And this chart is important from a historic perspective because sometimes, as Stephen told you at the beginning, MVLS works on tangled title. They work on houses that may have not had a new deed in 60 years. Someone's been living in the house, but it wasn't properly transferred from one estate to new owners, from the estate of those new owners to the next owners. And so tangled title matters sometimes get into inheritance tax issues from the 1990s or the early aughts. And I've done tangled title work prior to 1999, where the laws are different, the amounts are different, and the people who owe the tax are different. For siblings, there's no inheritance tax due, and that's been since July 1, 2000. For nieces and nephews and cousins and friends, there is an inheritance tax due. So many people want to leave assets to nieces and nephews. There's a 10% tax due on the receipt of that asset. It's due to the register of wills. You should familiarize yourself with the exemptions. The exemptions include close relatives. Those are people up the line of ascendancy, parents, grandparents, great-grandparents, and down the line of descendant, children, grandchildren. Your siblings are exempt from inheritance tax. Your spouse is exempt from inheritance tax. That's your close family, according to the statute. Life insurance, the direct designation of life insurance is exempt from inheritance tax. So if you have a $10,000 policy and you make your niece the beneficiary, she gets the cash, she doesn't owe money to the register of wills. If you have a $10,000 life insurance and it passes through your estate to your niece, 10% to the register of wills. A direct designation of life insurance is exempt from inheritance tax. Any public policy reasons why? Any reason you can think of why life insurance would be exempt? Because the legislature said, how are they going to pay this 10% tax? Oh, I know. You get a life insurance policy on your life, you designate it to the beneficiary of your estate, then they have liquidity to turn around and pay the register of wills. That's why. So it's an important tool. If you're going to leave an inheritance tax subject beneficiary a big asset, maybe throw in a little cash so that they can pay that tax. And it's due on the total estate. See that red rubber ball on the side? Everything that you own taxable to your Social Security number, including life insurance, IRAs, houses, cars, tangible. Everything you pass on your death is subject to inheritance tax unless there's an exemption. So lots of people say, well, you know, I'm leaving my IRA to my friend, and because it's a non-probate asset, there's no tax, there's no inheritance tax. Wrong. There is still an inheritance tax, 10% due to the Register of Wills. Yeah.
Got a couple tax.
Oh boy.
Questions.
Yep.
Okay, if in the will, you state that you're leaving, I guess you're giving things to your siblings, living or deceased first servants, will the inheritance tax still be applicable for the nieces and nephews?
Sure. So inheritance tax will be owed by nieces or nephews who receive the gift. If your siblings survive you, no inheritance tax. If one of your siblings dies before you, that sibling's children owe an inheritance tax. And this is not our only slide on inheritance tax, so we'll get into it more.
Okay. The other person, and I think this is going further than what we're going to cover today, but
Yeah.
we'll cover it in another training, is you got into the title issue a little bit. They're asking about transfer tax to put the deed in the person's name, whole other type of tax. And I think
Yeah, that's awesome.
that's relevant. I mean, that'll be relevant in another conversation.
Yeah, so I can touch on that briefly, which is to say, if you look in the tax property article 12108 exemptions, read through all those exemptions. It's like A through UU. So there are a bunch of them. Real estate passing from an estate of a decedent is exempt from transfer tax. Real estate passing from a living trust of someone who's dead, exempt from transfer tax. As a matter of public policy, the state of Maryland wants you to be able to make a new deed when someone dies. So those transfers are exempt. So now we've talked about non-probate transfers. Many assets can pass outside of probate. Now let's talk briefly about wills. And I say briefly because so much of estate planning happens unrelated to wills. Wills are important, everyone should have them, but giving gifts through a will is pretty uncommon, to be honest. Anyone over the age of 18 who is legally competent can make a will, as long as they understand the natural objects of their bounty. Again, the natural objects of your bounty, your children, if you have them, your spouse, your siblings and parents, if you don't have children, the natural sort of way that you would give assets. The nature and extent of your property. Can you tell me in our private meeting that you have a house, that you have a car, that you have a bank account? And can you tell me in our private meeting, I have children, but they're not the best reflection of me in society. Instead, I want to leave all my assets to my sister. She'll know what to do. Can you tell me in the private meeting, I know the natural objects of my bounty. I know I have a house that people rely on for property, for housing. And I want those people to have my house when I die, or I want my house sold and the proceeds distributed to these people because I don't want these people living in my house after I die. Can you tell me, can you interrelate those elements into a rational plan? Execution formalities, making a will is super easy. Has to be in writing.
That can be handwriting. That is not the same as a holographic will. Handwriting is not the same as a holographic will, which are beyond the scope of this program, but it's more than just handwriting. Has to be in writing, typed or handwritten, signed by the testator or some other person for him in his presence and by his express direction, and attested and signed by 2 or more credible witnesses in the presence of the testator. So written, signed in the presence of 2 people who also sign, having watched the testator sign. Super simple. No notary. Anyone can be a witness as long as they're over the age of 18 and themselves have capacity. Don't need a notary for a will. And it is a tragedy if a person intends to make a will and they go through the process of having it notarized, but there's no second witness. Because it says, this is my last will and testament. All the wishes, I've signed it in front of a notary. That is not a will, that is a wish. And it is meaningless. Yes.
So, because I've heard this debate, does the notary count as a witness?
Yeah.
Okay, so it would be me, the notary, and one person.
Absolutely. Yes.
Okay.
Yeah. And the statute in the power of attorney statute says the notary can be the second witness. You don't have to say it here because it's just another adult. We were talking about execution formalities, making sure that if you want to make a will, that you sign it in the presence of 2 people who also sign it, saying that they watched you sign it. It sounds like I'm being repetitive, but those are the execution formalities. A will is signed by a testator in the presence of 2 people who also sign it, having watched the testator sign. A paper writing signed by 1 witness is not a will, it's just a wish. Holographic wills are beyond the scope of this conversation, but please know, just read the statute if you're interested in it. So I recommend approaching will drafting through an estate administration lens because it helps you remember the things that you're going to include in your will. The will comes into effect when you die. Right up until then, it's not your last will. You could make another will. When you die, whatever your will was, the last one you executed, is your will. And it must provide for certain things, and we're going to walk through those. 1, your will must indicate that your executor can serve without purchasing an insuring bond. Bonds are a whole topic, and there are 2 types of bonds. One is an inexpensive bond, and one is an expensive bond. You want your executor to be able to serve as inexpensively as possible, and to do so, you're going to excuse the necessity of posting bond except as required by law. I'm going to show you the language for that. You're going to authorize your executor to pay funeral expenses without court approval. Also important, saves a little money, saves a little time. You want your executor to reimburse whoever paid for your funeral without having to go to the court and say, can I make this check out to this person who paid for the funeral? You want to include an instruction as to the payment of any death taxes owed by a legatee. Again, we're going to touch again on inheritance tax and how this works in a will. You can either say my estate should pay the inheritance tax, or you can say each individual legatee should pay his or her pro rata share of the inheritance tax. Your will should include a provision for the Uniform Transfers to Minors Act. If there's a chance that a person under the age of 18 is going to receive a gift under your will, please include UTMA provisions so that instead of requiring the appointment of a guardian of the property, which is expensive and time consuming, use UTMA, which is cheaper and permits access to the funds for the minor's benefits without court approval. Your will is going to include nominations for custodian, an UTMA custodian, and a guardian, either both guardian of the person and guardian of the property, where there may be minors. Either you have children who are under the age of 18 and your will is providing someone to care for your children until they become adults, or one of your legatees may be a person under the age of 18 and you want to make sure there's an instruction who's going to manage their money. Your will should include the nomination and contingent nomination for the executor. Here in Maryland, we call that the personal representative. So I use executor because it's literally less words. But it's elsewhere it can be called a personal, elsewhere it can be called an executor or executrix if you want to get fun. And then last and literally least is the gift recipients and contingent gift recipients. We're going to walk through gift giving language in a will, but we've talked about making asset transitions through non-probate means by having co-owners, designations and beneficiary designations, designations by contract, co-owners of real property, co-owners of bank accounts. There are other ways to transfer assets on death that don't require probate. So gifts in a will, you have to make them very thoughtfully because you want to make sure if you're giving assets or money in a will that there are assets or money in probate that will fund those gifts. So this is the bond language. I direct my personal representative be excused from bond. And again, you're going to get these slides. I direct my personal representative to pay my funeral expenses, including the cost of a suitable marker for my grave without the necessity of a court order. Inheritance tax language. You have to talk to your client about this. Should the individual receiving the gift pay the tax, or should the residuary estate pay the tax? What this means is, if you, just as an example, if you have an estate and you're leaving it in shares, one share to an inheritance tax exempt recipient, like a sibling, and one share to an inheritance tax subject recipient, like a niece or nephew, is it fair? Does the client in his or her heart want both of these people to bear the burden of the tax? Or does the client want the person who owes the tax to bear the burden of the tax? And so that's an apportionment clause. So there are two examples here. The first one says, I direct all taxes payable by reason of my death, whether payable by my estate or by the recipient of any such property, to be paid in full without apportionment by my personal representative out of my residuary estate. That means the niece is getting $50,000, the sibling is getting $50,000, the residuary estate is paying the $5,000 inheritance tax, reducing each residuary share by $2,500. Or in the alternative, all taxes payable by reason of my death shall be apportioned among the persons benefited in the proportion that the taxable value of the property or interest bears to the total taxable value of property or interest received by all persons benefited. This pro rata. So the niece is paying the $5,000, the sibling gets $50,000, the niece gets $45,000. That's what that means. So either the estate pays the whole tax and everyone bears the portion burden, everyone bears the burden, or the recipient who is subject to the tax, that person's gift is reduced by the value of the tax. So either it's not apportioned or it is apportioned. That's the sample language. UTMA provision. I direct any gift hereunder to any person who has not yet attained the age of 21 years shall be made under the provisions of the Maryland Uniform Transfers to Minors Act, and such gift be distributed upon such person's attainment of 21 years of age. My PR shall appoint the custodian. No person under the age of 18 can own property. No person under the age of 18 can own property. So if a legatee or heir of your estate is receiving a share and they are under the age of 18 and you don't have a will providing UTMA authority, then the orphans court is going to say, you have to have a guardian of the property. So then a court has to appoint a guardian of the property, and the distribution has to be made to the guardian of the property. Now, a guardian of the property we touched on earlier. One of the burdens of a guardian of the property is an annual accounting. So that guardian of that minor's property now has to file a report with the court every year. Another burden in the instance of a minor recipient is that that account is court blocked. That guardian of the property can't use the money without a court order. When you leave a gift to a loved one, surely you want them to be able to get the benefit of that gift. But unless you specify that gift should go to UTMA, the guardian of the minor's property can only make withdrawals with a court order. And they have to go to court every time that the kid needs new shoes. It is burdensome, it is expensive, and it can be avoided. The other benefit of using UTMA, a guardianship terminates when the minor attains the age of 18. No 18-year-old should have access to large dollar values. UTMA permits holding the money until age 21. So you get an additional 3 years of maturation of the frontal lobe of the brain. In a will, you can nominate who should serve as the custodian. So you get to pick who holds that minor's money. If you don't want that minor's parent, because that minor's parent has demonstrated irresponsibility, pick someone else. You're writing your will, you can do that. Guardian of the person of a minor child. So yes, we can avoid the need for the appointment of a guardian of the property, but if someone's under the age of 18, they will need a guardian of the person. Here you can nominate that person. You can nominate one person, you can nominate two people, you can nominate two people contingent that they're married at the time. Lots of ways to draft that. This is an example. Now we get to the gifts. So this is Latin. I just put this up here because it makes people nervous. Per stirpes, per capita. Per stirpes means by the roots. Per capita means by the head. And if he or she survives me. We're going to walk through a couple examples of this. Per stirpes, if you leave a gift per stirpes, I leave my house to my sister, but if she fails to survive me, this share shall go to her children per stirpes. It means if she's not living, her children get it equally. And if there's a child who's predeceased her leaving children of that child, that set of people takes that person's from the roots, that it takes their share. So if the sister has 3 children, one of them is dead, 1/3 goes to the sister's child, 1/3 goes to the sister's other child, and 1/3 is divided further for the 3rd child's children. That's per stirpes. Per capita, don't ever use it. Just strike it. Never happened. Per capita means by the head. When you die, whoever in that class is living, you count the number of people and it's divided accordingly. So if you say to my grandchildren per capita, then when you die, that class of grandchildren is set. And if there are only 9 at the time, only 9 grandchildren get the share. So it doesn't go to the descendants of the predeceased child. And if he or she survives me, if you use this phrase, you need to have something to happen if they don't survive you. So when we do estate planning, we walk through terrible hypotheticals, like what happens if, what happens if, what happens if, and my job is to create disaster scenarios. And I do that so that people can tell me, well, if my sister is dead, I want this person to have it. Or if my spouse hasn't survived me, I have children from my prior marriage, I want to make sure it goes to my children of my prior marriage, things like that. Contingency planning. When you give gifts in a will, you get to decide how they take it. You can make a gift of an absolute interest, which means when you give it to that person, they can give it away to whoever they want. You can give a gift in a life estate, meaning you give a gift to that person, but only for their lifetime. They can't control it on their death. It goes wherever you direct it on their death. You can give a gift of a remainder interest. So let's say I give my house to my sister for her lifetime. She lives there, she needs a roof over her head. But on her death, I want the house to go to my kids. That's a gift of a life interest and a gift of a remainder interest. You write that down, that's what it means. You can give property through your will to joint ownership. We talked about joint ownership before. There are 3 basic types: joint tenants with rights of survivorship, tenants by the entireties, and tenants in common. You can write in your will, I want to leave my house to my 2 children as joint tenants with rights of survivorship. And when the executor or that person's attorney writes that deed, It's gonna say undivided interest, 50% to this child, 50% to this child, with rights of survivorship. So that when one child dies, the entire interest is concentrated in the other child, versus another option, tenancy in common. If you want to make sure each of your children has an interest that they can pass to their own children, you want to do it as tenancy in common. 50% to this child, 50% to this child, tenancy in common. So their own estate plan governs the next step. Yes.
Might just happen. Once that happens, the children can decide if they want to change that.
Absolutely.
Okay.
Yes. Yeah. So that's a great question. So when you give in your will, you make instructions. And then once those assets pass to those people can change their minds. So if you leave a house to your children in your will as joint tenants with rights of survivorship, either before the asset is distributed by an agreement among the heirs, or after the asset is distributed by an agreement by the new owners, you can change that. Nothing is set in stone. And then you can give gifts and trust. This is pretty common. I want to take a moment. Oops, not that way. Yeah, I want to take a moment here to talk about gifts to minors and trusts and low-income estate planning, and something of an anecdote too. So everybody over the age of 18 who has at least one person they love and at least one asset needs estate planning. They need a healthcare directive. They need a financial power of attorney. They need a will. What they need also is counseling from knowledgeable people about passing their assets in the way that reflects their wishes via a will through probate or non-probate vehicles like co-ownership of accounts, pay on death bank accounts, transfer on death brokerage accounts, life insurance contracts, beneficiary designations for retirement accounts, and don't forget the MVA title that permits transfer on death of a vehicle. These are all non-probate transfer tools. One tool that you should be versed in speaking with your clients about are life insurance beneficiary designations that have provisions built into those contracts that permit you to give the life insurance to someone to hold for the benefit of a minor. Giving life insurance or any asset to a minor is complicated because no one under the age of 18 can own money. So if you name my child, I have a $10,000 life insurance policy, and I name my 6-year-old as the beneficiary. This happens all the time. And I die. My 6-year-old is the beneficiary, and inside that life insurance contract, it's going to say, oh, if the beneficiary is a minor, the only person who can claim this policy, this benefit, is a guardian of the property. And so then you have to go to a court, become a guardian of the property, take your guardianship letters, which Maryland doesn't even have, to prove to the life insurance company that you are responsible for this minor's property, and then they make the payment. Some life insurance contracts have an alternative, it can be very handy. The life insurance contract says, I want to make my child the beneficiary. If my child is under the age of 25 or 21 or 18, all contracts vary, I want this person to hold the money for my child, and then when my child attains that age, they get the money. So some life insurance companies inside their contracts have the tool to designate someone to hold that money for your child. I say this because as an attorney, when you're counseling somebody, you are capable of providing really great counseling. And when I say read the document, I literally mean have your client call the company, Mass Mutual or Franklin Temple, whatever, and have them send a beneficiary designation. And then you can read it. And they'll email it. They can email it now. send it to the address on file by mail. Have them do that. Read the contract, see what it says, and help that client complete it in the way that is going to benefit their family the most. The anecdote is, and it sort of defeats my the thrust of my argument. The anecdote is, I had a client who, she wasn't my estate planning client. Her son ended up being, in a way, my client. She designated her dad under one of these life insurance contracts to hold the money for his son, her son. So grandpa was designated the custodian for grandson. And the life insurance company contacted him and they paid out the benefit to him and he stole the money. He was out of state. And I don't remember who looped me in, but I was like, oh, come on. A person I went to law school with happened to be in the financial crimes division of the state's attorney's office in Baltimore City at the time. And they were able to extradite him and get him to sign a restitution agreement to pay the money back. He did. He took out a home equity line of credit and paid it back. But the slide, 2 hours ago that said, make sure you trust the person you're nominating. Money is hard. Money changes people, and it is really important to trust the person you're nominating, to take care of your kids, to take care of the money for your kids, and it's important for an attorney to be able to counsel on these things, to know, what happens if, or what happens if this. Okay, that was the end of that story. So we talked about gifts and trust. Like, if you have a minor child, would it be better to leave the gift to them in Atma or to leave the gift to them in trust? If you have a child, whether it's an adult or a minor, who lacks the ability to make or communicate their own decisions, don't leave them a gift. Leave them a gift in trust for their benefit. There are particular types of trusts that allow for someone to hold the money for the benefit of that person who can't make their own decisions, and also allow that person to qualify for means tested benefits. And so if you're encountering a client who has a prospective beneficiary with special needs, hop on the phone with the mentor attorney, say, what do I do about this? Because if I leave money to this person, there's going to have to be a guardian of the property. If I don't leave money to the person, then it would disrupt this family's estate plan. Who's going to provide support? There's a middle road, special needs trust, so that you can leave money for the person with special needs and also permit that person to continue qualifying for means tested benefits. So just hop on the phone. All right, now we're going to get into examples. Any questions so far? Yes.
Can we actually hold questions for the end? We have more people now.
Oh my God, you mean, what do you mean?
Or we just have someone else talk.
So I have like 5 to 7 minutes left, is what you said. I will shut up. All right.
Yeah, we can
We're going to hold questions for the end and circle back closer to noon. I'm going to walk through some examples of dispositive provisions that could be written in a will. 1, I give my life insurance to Brian. If you have a provision that says I give my life insurance to a person and there's nothing after it, like if he survives me, or if he fails to survive me to his descendants per surpice, or if he fails to survive me, this gift shall lapse, and Brian dies before you, it goes to Brian's estate under the terms of Brian's own estate plan. So if you don't qualify the gift, if you don't have anything written after it about what happens if Brian dies, it's going to Brian whether he survives you or not, and if he fails to survive you, it goes to his estate. Next, I give my house to my domestic partner if he survives me. So if you're giving your house to, oh my God, I forgot about the next slide. There's a way for your domestic partner to receive a house without paying inheritance tax. Register the domestic partnership, but even if you fail to register the domestic partnership, if that person is on the deed as a joint owner with rights of survivorship, they can be exempt from paying inheritance tax. I give my car to my sisters or the survivor of them. So here, you're building in a contingency. My sisters But if one of them has died, the other is receiving the car. I give the contents of my house to my grandchildren who survive me. So grandchildren is a class of people. While you're living, you may know all your grandchildren's names, but there could be more born after you write this will. There could be fewer when you die, if one of them dies before you. So it's a class that will only be defined after you die. And I give my residuary estate to my friend. If he survives me, that's an inheritance tax subject recipient. And if he fails to survive me, I give the whole shooting match to the Maryland Volunteer Lawyer Service. And then this paragraph at the bottom is a sine clause. If you're giving a charitable gift to an entity, you want to include a paragraph that says, if that entity doesn't exist, then my personal representative, in his or her sole discretion, can redirect that gift to a similar charitable entity. So these are just examples of how to write gifts. Make sure you have a contingency in place. Make sure you have everyone's name spelled correctly. I have one decedent who has 2 children named the same thing, Junior. That's complicated. Just make sure you gather that information up front so you can do a good job of drafting at the end. I have 4 minutes to talk about disinheriting a spouse. You can try to disinherit a spouse, but public policy says your spouse is going to have an interest secured by statute. In Maryland, we have something called the augmented estate. So if you write your spouse out of a will, your spouse can elect to receive a gift against the terms of the will. And that gift is determined not just by your probate assets, but by all the assets that were taxable and under your control at your death. And there's a formula for how much your spouse gets at that point. You can, your spouse can waive his or her interest in your estate. So when I have a client who's leaving gifts to their children and they're not leaving gifts to their spouse, but they're doing planning together, just have the spouse waive the right to elect against the will. So my spouse acknowledges the spousal right and hereby forever waives and releases that right and consents to the gifts I'm making, including the non-probate transfers. So anything can be done by agreement. You can disinherit your spouse by agreement. Briefly, touching on the registered domestic partnership again, there are 2 ways. One is the slide before, where you file a writing with the Register of Wills. The other way is in the Health General article, where you enter into a domestic partnership by a separate writing, and either of them get you the inheritance tax exemption. So when you're a when you're a domestic partner under the Health General article, you can receive a joint primary residence as long as you're jointly titled with rights of survivorship and you're a domestic partner. That half of the primary residence can pass without being subject to inheritance tax. If you go through the process of having a registered domestic partnership where you've registered it with the Register of Wills, then you get the free pass for all the assets from inheritance tax. That's a big deal. So if you have clients who have someone they have partnered up with, they have a committed relationship, they're interdependent, financially interdependent, they're exclusive, and they're not married to or partnered with anyone else, it is a great cost-saving tool. Yes. Yes.
So in one of the slides, there's a giving sentence that I give my house to someone. What does that really mean? I give my house. Like, what happens to the expensive furnitures or anything valuable inside the house?
That's a great question. And the question is, when you give someone your house, what happens to the stuff inside? And it really is whatever you write down. So here I give my house to my domestic partner. I give the contents of my house to my grandchildren. Then we're sort of being very specific. The stuff in the house goes to this one set of people. The house itself goes to another person. If I was silent on the contents of the house, that it does make it confusing. So to the extent there are issues with tangible personal property, you should be very specific. And tangible personal property can have monetary value and also sentimental value. And tangible personal property can be the subject of a dispute, even if it's valueless for money purposes, but very valuable for family sentimental purposes. Things like photographs are tangible personal property and contents of a house, and people will destroy family relationships over those items. So if your client thinks there's going to be an issue, counsel your client to be specific about it.
Okay, so do you know how will court decide on the content or to say I give my house to?
So that's a great, yeah. So how would a court decide? The court would probably, if the document is silent on tangibles, the contents of a house, the court would probably decide that that's part of the residuary. So if this gift to the grandchildren wasn't here, then the residuary estate would probably be not the bricks and mortar, but the stuff inside would pass to the friend William under this example, if the grandchildren were not designated to receive the contents.
Okay, so like expensive furniture get sold and become part of.
Yeah, or it could be sold. So in my wills, when I do a will for a client, I have a section on tangible personal property, defining the tangible personal property, what it is, giving it away, and giving the personal representative authority to sell, donate, or discard anything that's not suitable for giving. Because the house is full of stuff. Most of it is worthless financially. Some of it is highly sentimentally valuable. And the rest of it is just has to be dealt with. So giving your personal representative the authority to make discretionary decisions about it can be helpful.
Thank you.
Question came in a little while back on the chat. Can UTMA be used for grandchildren?
Absolutely. So the question is, can UTMA be used for grandchildren? UTMA is general and can be used for gifts to anyone who's under the age of 21.
If someone signed a spousal waiver and they change their mind later, can they litigate their share?
I mean, the answer is anyone can litigate over anything, for sure.
Are what I have on the chat. I guess I would invite if anyone else on the chat has last minute questions and if anyone.
So I know you kind of said that anybody over the age of 18 can have a will, but how do you really kind of, even for myself, like impress that upon somebody? Because, you know, at 18, it's like, I might have a checking account that I don't share with my parents. Like, I don't have anything worth putting into a will.
Sure.
So
sure.
it's like, at what point, like, I've been taught, like, if you have like car and maybe some valuables, get a will. If you have property, then get a trust. So like, would you
interesting.
right. So it's just like, would you have any recommendation for bare minimum other than the fact that you should have one?
No. Yeah. So when I say everyone over the age of 18 needs a will, it's really not about the stuff. It's about decision making. And it's about naming somebody who can file your final tax return. So if you have an income and you file a tax return and you die, your estate may be owed a refund because there's withholding. But if nobody is authorized to file your taxes, then you're giving up money. Now, money is not the most important thing in the world, but it's a thing. Naming that person to make decisions with respect to your stuff that isn't valuable, the contents of your house, the computer, to, you know, who gets to control your bedroom. Like the personal representative may or may not be making gifts, but that person has authority, and institutions and other people have to listen to them because they have the piece of paper. So it's not so much about stuff. And you brought up earlier pay on death accounts, and I realized I did not have a separate slide to talk about it. So I'm happy to answer any other questions that have popped up, but I also want to jump back to this one and talk about the non-probate methods of transfer of all of these different assets. Because it is, why am I talking about non-probate transfers if I'm not going to teach you how to do it? We talked about the house. It's going to be the subject of a different training, but there are ways to make sure your house gets to a new owner by deed outside of probate. Like a life estate deed, there are a couple of varieties of life estate deed. You should know more about it before you draft one. Like a joint tenancy deed, if you want someone to own it and you want to co-own it while you're living, add them to the title to be a joint owner. The car, look at the title. Is it does it have a transfer on death on it? If it doesn't, for $20 and a trip to the MBA, you can add a transfer on death designated to your car. So that when you die, there's a new owner just like that. They just have to take your death certificate and the title to the MBA. The checking account and savings account, bank accounts, all the banks have POD forms, pay on death forms, POD, that allow an owner to name a person or people to receive the account on the death of the owner. Those people just have to present a death certificate, the account's divided, checks are issued, no probate. The life insurance talked about beneficiary designations, look at the document. Tangible personal property, where is it located? If it's in the home, if the person doing the planning foresees there being a dispute, make some specific instructions about it. And to go back to the bank statements, when you look at a bank statement, at the top, literally the address of the owner is going to give you information. So it's going to say Betty, the owner, or Betty and Bob. And if Betty and Bob's names are both on there, yeah, you either assume that they're joint owners with rights of survivorship, or you want to look a little closer. It could say Betty, POA. If the letters POA are on that address, it means there's somebody listed as an agent on that account. You have to look a little further. It could say Betty, POD, in which case somebody's been listed as a pay on death designee. Look a little further. Who is that? Where's the paperwork? It could, I've never seen it say POA and POD, but it could, because you could name someone as an agent on the account and also name that person or someone else to receive the account on your death. Those are incredibly important tools to avoid probate and make sure someone can manage your affairs for you. But two things: one, clients aren't asking for that when they go to the bank. Two, if they do ask for it, the banker's going to mess it up. So I give my clients my cell phone number and say, when you have an appointment with the bank, tell me, I'll be available. If they tell you to add a joint owner, call me. Just phone a friend, because don't add a joint owner to your bank account unless you talk to your estate planning attorney first, because that disrupts your estate plan. And bankers, they don't understand it. They don't get it. So, and my job is not to educate them. My job is to make sure my clients are protected. So each of these assets has a way to pass outside of probate. Tangible personal property can be passed outside of probate, by the way, by a gift letter. Today, October 12th, 2023, I gave the entire contents of my house to my best friend. My best friend holds this letter. I put this letter with my will. I don't own any tangibles when I die. I gave it all.
Would there be any sort of tax computation, like for example, for the checking account, if you pass through your heir by that or by will, would that be a difference?
Absolutely. Great question. So when you have a pay on death, I do want to note we're over time. I can talk for hours. You've already seen that. When you have an account, whether it's a checking account, a savings account, a brokerage account, any of these accounts with a pay on death designation, or for brokerage, it's called a transfer on death. As soon as you die, there's a new owner. It happens automatically. The date of death, the new owner takes over. Every bit of income leading up to that for that year, from January 1 until the day before you die, is your income. Every bit of income from the date of death forward is the new owner's income. So before you die, this has to be reported on your final personal income tax return. After you die, all that income is reported on the new owner's return. If you don't have a pay on death or transfer on death designation, you die, all the income from the January 1 through the day before you die is on your personal income tax return. All the income from the date of death forward until that account is closed is on a fiduciary income tax return, a 1041 and 504 for the estate of you. So you up until the day before you died, the estate of you after that. When that account gets closed, then the new owners own it through probate, then they take over. But there's a new tax entity created on your date of death. And that is also a topic for a different discussion. But it is important to know who gets taxed for that one.